I hope this session would make things interesting, because normally I know a session after a good lunch is always boring. But I hope we try to come up to your expectation. And for this subject, since morning we have been discussing on the Constitution and the law relating to Constitution. And we have been interested to talk to you guys on a particular segment in the Constitution, which is very relevant to me, because as very rightly Justice Shekhar once said, you remove everything from the Constitution, but not part 3. If you remove part 3, then there is no Constitution. Then he said, from part 3, there are two provisions. One is 14, the other is 21. If you remove them, there is no Constitution. Anyway, there are two segments today on which I am expected to talk. I am only going to briefly introduce you the subject. My younger brother will be able to take you on a long trip on this particular subject, because as far as I understand, we need not deliberate, at least I need not deliberate on the issue of part 3 of the Constitution, because right from Article 12 to Article 35, there has been innumerable judgment right from 1950. Ramesh Thapar, A.K. Gopalan, right now up to Coelho, discussing on various aspects of the Constitution. And I don't think I will bore you with what exactly was said in this judgment. Probably I think you are wise enough to read those judgments from the various law reports, SCC, SCR and other. So I'm not going to, except there are one or two provisions which I feel, which I consider are the backbone of this particular chapter. Rather, I would like to concentrate my session on my timing, and I will be dwelling only on part 4A. You see, because that has become very relevant. Because there are certain things on which we need to look into, maybe comment on, maybe probably at the question and answer session, I expect you to have a very lively interaction, because this is part 4A is going to be a very lively session. That's what I understand. As I said, there are 3 provisions of part 3 which I felt was very important. One is Article 13. It has been categorically held that the state cannot enact any law which would be inconsistent or in violation of any fundamental right guaranteed to you. To that extent, the court can always strike it down. So absolutely no quarrel. Then we have provisions, namely Article 19, with exceptions which are available, which has been tested time and again, right from freedom of speech and other things, right to property having been taken away. Then we have a very, 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 very important article, Article 21. Right from Maneka Gandhi, A.K. Gopalan, up to Maneka Gandhi, how the Supreme Court has molded, how it has defined, it is not merely life and liberty, it is something more than life and liberty. And the court has even got to the extent of saying it is not merely an animal life, it is more than animal life which we have. Anyway, I don't want to, because you must have all studied and you must be thinking at 2 o'clock, here, why is he boring with all these things? I'm not going to do that. Knowing fully well. Now, there are 2 aspects on which I wish to concentrate, because 20 minutes was the time which Shivani told me. I have already consumed, I think, 3 minutes, 17 minutes. Let me concentrate on 2 things. I was today very happy seeing the citation which you are, in fact, we had started this in our Supreme Court Bar Association. We had stopped giving bouquet and other mementos to people. we were giving only one page from the Constitution, that was the preamble. Because when I happened to be in one of the international conference, somebody asked me, what is this? You all claim that one of the best constitution, these, but solved with so many amendments, so many, they were trying to make fun of us. Anyway, and I told him, you don't read the entire constitution. You read only the first page. It will tell you what is our constitution is all about. And I'm going to discuss on the preamble. I'm not even going to discuss anything about part 4, namely the directive principle, because you know, even though it says that it is not enforceable in a court of law, but over a period of time, now we know part 4 is always related to part 3, and now it has become an enforceable right. Even though in the constitution you may say it is not enforceable, but indirectly it has been enforced, because with everything you tag on Article 14 and 21, it gets enforced. That is how the Supreme Court has moved from 1950 to 2017. That reminds us of the last segment on which I wish to take you in detail, that is Part 4A, which came about through 42nd Amendment. Very rightly, Mr. Nafde, senior to me in the profession by 6 years, and also Mr. Muncham Garg, who was 2 years senior to me in the law faculty. We had seen those days, the dark days when Supreme Court, where all the lawyers used to meet, they were forcibly closed, locked, because it was always felt 2 lawyers joining together will always create a problem for the government. So the lawyers were never allowed to interact, at least in the Supreme Court premises, but they knew that we will always meet at other places over a cup of tea or over a cup of glass which we always hold. Because I still remember that when I told one of the gentlemen that I don't take, Kada, what kind of member of bar you are if you are not a member of my bar. So that is how the whole thing is. So the lawyers always get the bad name that if you say you are a member, they always ask you, are you a member of this bar or the other bar? Anyway, that's that joke apart. So we still remember what happened during those years, 1976, with whatever other provisions, these laws were incorporated through amendment which was brought in, because by this time we all knew what exactly Keshwan and Bharati, what exactly the basic structure, everything, amendment power, 368, we all know this, so I don't think we need to dwell on this. 3177 was the time when this particular insertion in the Constitution, namely Article 51 capital A, 3/1/1977. 76 it was brought about, 77 it was given a final shape. Along with other, as rightly said, that 356(5) of the Constitution, but all those things ultimately in the year 19. Anyway, we don't want to, what Janata Party did, what other party did, let's not get into that. For me, for this discussion, it's only 2 subjects, 2 segments of the Constitution, because I believe in one thing. Why I'm saying that Part 4A has got some relevance and connection with the preamble of the Constitution. Let me just, for your convenience, because I had always felt, the more the number of times you read the Constitution, every time you get a new interpretation and new idea. So that doesn't mean that probably what you thought the first time was wrong and the second time is right. No. So let us just try to read only just 4 lines from the Constitution, then try to connect it with 51A. That is what is my intention. It says, we the people of India solemnly resolved to secure, I am removing those provisions which are not required, secular and other things, where it doesn't concern us, to secure to all its citizens. So it is a resolution. It is a self-undertaking given by the people, our forefathers. In other words, the Constitution, even maybe that those people had, after debate, had come out, but this is a Constitution which has been given by us to us. That's how we understand the Constitution. Then it talks about three: justice, social, economic, liberty of thought, expression, belief, faith and worship. As far as liberty of thought, part of the fundamental right, I need not deal with it. Equality of status and opportunity. Again, what is very important is fraternity, assuring the dignity of the individual and unity and integrity of the nation. This is, please keep this in mind in the context of duty. Because you may be wondering, how come suddenly, maybe was it out of fear at that point of time in 1975, as the power which was there was fearing that probably the people will go beside and there must be some provision by which people could be controlled. But before that, please try to understand. When the framers of the Constitution, right from 49, when they were almost 48, 49, when they were debating, can you say that it didn't occur to the people, the framers of the Constitution, that they did not want to have fundamental duty as part of the Constitution? Why suddenly in the year 1976-77 this was brought in? There is a big story behind it, because I was told that Mahatma Gandhi wanted to have also fundamental duty. He wrote in his book, but unfortunately when all these things were debated, fundamental duty was never made part of the Constitution. But the original idea, because as far as fundamental right and other chapters are concerned, we did borrow from France, we did borrow from the USA, whatever was the good provisions in those. But as far as fundamental duty is concerned, can you tell me from where did we borrow this? Huh? Correct. From Russia, chapter 10 of the Constitution of Russia. The only difference is, if you just see the language there and the language here, because I somehow don't agree, because every time you may say, like when part 4 was there, he said it will never be enforceable in a court of law through a writ. But ultimately we know right to fair wages being paid, or for that matter anything concerning environment. All these things are slowly getting implanted into part 3 and are being enforced. So similarly, if you look at part 4A, I will just read only because there are only 11 in numbers. Just let me read it. 51A, fundamental duties. It shall be the duty of every citizen, A, to abide by the Constitution and respect its ideals and institution, the national flag. Nobody says that they will not follow what is set out in the Constitution. But what is important, which has become center of controversy, the national flag and the national anthem. Recently you must have seen that is, a lot of things are under controversy. Supreme Court said when national anthem is being played, you must stand up. There were some segment of the population which said that they will not, because it doesn't allow them, their probably faith doesn't allow them to. So also they said for Vande Mataram. I don't want to get into all this thing. Now the second is to cherish and follow the noble ideals which inspired our national struggle for freedom. This was thought to be put, I remember, when our then HRD minister wanted to get something put about our freedom movement and this thing, immediately an objection was raised. So what I am trying to say, that whatever is sought to be introduced now, because all these years there was always a policy of appeasement which has been going on. Now since it has been realized that let us give shape to these fundamental duties, that is how, that is as far as we wanted to change the educational curriculum, wherein wanting to highlight whatever freedom fighters like Bhagat Singh and other people did, Subhash Bose, it is all being, now there were objections to include them in the educational curriculum. Anyway, we leave it at that. Why I am saying, I will say leave it at that, then I will give you the answer what exactly we propound. Then C, to uphold and protect the sovereignty, unity, I'm not interested, integrity of India. Sovereignty, unity, fine. Integrity of India. And you know what is happening, one of the northest part. Integrity is there or not because they claim a special status. Anyway, that's also a matter of in the Supreme Court. You all know about it. Then to defend the country, and this is what is very, very important. Because 2 months back, our Prime Minister went to the state of Israel. I also happened to be in Tel Aviv and Jerusalem 4 years back. On one of the delegation with the Bar Association of India, we had an inter-exchange program with the Bar Association of Israel. We saw young children of 16 and 17 years. They're all in the army or serving. Why I say this? Not because that they compulsorily require people to defend them. If it is put as an option, they may not have soldiers to defend them. It's not that. More than that, something is very important. It brings discipline. Because you had always seen, so I always been advocating that we must have compulsory military training for students after they have cleared their 12th class. It has to be there. In some way or the other, 2 years you serve, maybe that you can do your graduation because number of people are doing that while serving the army, but the discipline is brought. Nowadays, you know, please don't mind. I'm not saying that the youngsters don't have discipline or anything for that matter, but I think probably we would have been better off if basic discipline has been. Then we have to promote harmony and the spirit of common brotherhood amongst all the people. There is always a question mark about the brotherhood and all. Anyway, again, I don't wish to comment on that because then it will become, immediately somebody will say that I'm trying to make a political speech. I'm not. My only intention is to highlight some of the things on which what exactly is expected to happen. That's all. Sectional diversities and renounced practices of derogatory to the dignity of women. This I highlight because I was one of the counsel in the triple talaq matter in the Supreme Court. One of the arguments which I only took, which was appreciated by Justice Nariman, that has also been referred to. I said this provision, even though they initially raised a very fundamental duty, is not enforceable, how can we do it, we can't do it. But then, very easy to answer is, you tag on Article 14 and 21 to all the submission, automatically everything gets diluted and then you said, yes, this is correct. So one of the arguments which was argued was the renounced practices derogatory to the dignity of women. So we said this practice of talaq, in fact we even argued, having 3 women is also derogatory to, I'm not touching upon any religious sentiment or anything, please don't be under that, or not even say, even though they tried to touch upon the issue of uniform civil code, the court refrained itself from passing any order on that, so let us not get into that. But what was argued which impressed the court was that renounced practice derogatory to the dignity of women. So this point was well taken, so that is one aspect. Then you have to value, preserve the rich heritage of our composite culture. Then we talk about to protect and improve the natural environment, including forests. Whatever Supreme Court, the social bench is not able to do, now NGT is doing it. So what I'm trying to say, indirectly all these laws, even though you say that it is not enforceable, slowly are getting enforced in a court, through a court of law. But more than that, what I wanted to say is there should not be any compulsion or there should not be any agent to enforce. It must come within your DNA. What are fundamental duties in fact? It is that it defines your character. Whatever is set out herein, it only defines your character. So, if you perform your fundamental duty, I don't think your neighbor would have any grievance against you for seeking any right or anything for that matter. So, fundamental duty, irrespective of whether it is enforceable, like part 3, it should be without there being any compulsion from the constitution or any provision being there. Still, you should voluntarily abide, you must perform the duty which you expect a fellow citizen must in all sins follow and comply. Then you have to safeguard public property. Yes, this was a matter of discussion last week in the Delhi High Court. You all being student in DU, what happens during the time of election? Public defacement. We know that there is an act called West Bengal Act is there. You are not allowed to deface the public property. But still it happens. But then the court had to intervene and had to say, please don't do it. But do you think, should we not imbibe ourselves? It should not come in our DNA that we should not be doing it and we should expect the court to tell us? I think. So what I'm saying is discipline, that's why I insisted. Discipline is something very important, which must come within you. Automatically all these duties, all this chaos, confusion which are prevalent in the society, if all these duties which has been put, because you would also appreciate 1975, when the then Law Minister H.R. Gokhale, Justice Sunanda Bhandare's father, when he was the Law Minister, he was the author of the emergency, because at that time we all knew what exactly was happening. They immediately constituted a committee, which was called Swansea Committee, who was the External Affairs Minister at that point of time. A very nice gentleman. They came out with this. It was little different from what he had, but almost everything copied from the original text from the Russian Constitution, that is chapter 10. Because probably they wanted to inculcate at that time that Indians are not patriot, Indians are not disciplined. So probably it is by this process they could introduce this. So maybe that was the main motive, and that's how this has come into being in your, and very rightly, I don't think there should be any external force for you. Whereas in part 3 you understand it is always necessary against the state action. The right is claimed only against the state action. It is here your own fellow citizen. How will you enforce the fundamental, except in the case of a habeas corpus, how will you enforce a fundamental right against a private citizen? Even though nowadays it gets diluted, I know in Delhi High Court, in the public interest litigation, at least 40% of the cases are against illegal construction by your neighbor, the writ petition is filed. But very cleverly it is drafted. It says the inaction on the part of state authorities to stop, please issue a writ of mandamus. Even though indirectly you are asking your fellow neighbor. So what I mean to say is, in a roundabout manner you try to get. So these are all the things. What I say is, if it is imbibed in you, probably I think we will not be in a state of affairs as we are today. I think I have completed 17 minutes, because I wanted to reserve some time for a question and answer, so I don't mind controlling myself and not going beyond my allotted time. So as far as fundamental duties are concerned, there are a number of judgments which have been of late coming from the Supreme Court, but it is not purely on, as I said, it is not purely on interpreting part 4A of the Constitution. It is read with some of the provisions of the part 3 of the Constitution, namely 14 and 21. It gets almost enforced and implemented. And in fact, recently we were appearing in a matter relating to ban of plastics in Delhi. In fact, unfortunately, I am appearing for the plastic industries there. I am on the receiving end. But we were only trying to tell them, don't ban it, because we got international data to suggest that plastic is an indispensable item because it can be easily recycled, and we have scientific data to prove that it doesn't cause any environmental problem. Anyway, if you are not satisfied with our submission, appoint a committee headed by all the technocrats from the Environment Ministry, and you can easily do it. So what I mean to say is, at the most you can tell the state, because state may not be polluting. It is the individual or the companies or somebody else who is polluting. But definitely, as it is said here, both under part 4 and part 4A. So these are all certain limitations which are placed against the other, asking you to discipline yourself and perform your duty. which you are expected to do, so that probably this planet is worth living, and probably I think we can all see a smile in the. So I have deliberately not touched on any case law, otherwise you can go on right from Ramesh Thapar. I will start. Probably I think there will be too many questions, then A.K. Gopalan, then at least 2 hours on Keshavananda Bharati, Minerva Mills case, Golaknath case, we can keep on going. Absolutely, there will be no end as far as that is concerned. Then on directive principles of state policy, we can go on. Ranveer Singh, the first case on equal pay for equal work, we can start from there, and it will go on right up to then we can discuss Coelho's case also, then we can discuss Bombai's case also, everything we can discuss. Because one great thing, I remember one of the professor and one of the judges when we were over a cup of tea in one of the conferences we were discussing. He says in our Indian constitution, there are, like we play a game of card, we have a card which is called Joker. You can always fit into anything. So Article 14 and Article 21 is one which you can always fit into anywhere and you will get relief, as long as you are able to prove. So I think with this, I think I will not bore you much. Let me just wind up, and I am ready for any question answer. This thing I will do. After. Yes. Thank you.